can continue with this representation. And we made a number of points. It's not the same issue, of course, under 1.9, whether we can continue with this representation. And we are trying to figure out under rule 1.9 whether we can continue with this representation. And we made a number of points. It's not the same issue, of course, under 1.9, but certainly substantially related because we were talking about fluorocarbons when we helped NCC apply for the FDA application. And there are a number of things surrounding these facts that sort of make this factual situation complex. NCC probably is not going to consent, of course. NCC is a former client. We have Max Friedberg, but he passed away. But you also have to note that if he were still with the firm, he could not represent the state against NCC because the matters are substantially related. And that introduces us to the concept of imputation. So we are all in here one lawyer for purposes of conflicts. Then we ask the question, what kind of confidences would a lawyer ordinarily have learned in this particular situation? Again, we don't have a lawyer moving from one firm to another where we need actual knowledge of the information. We're using that presumption so that the former client doesn't have to reveal the confidences. And we have this presumption that if a lawyer was involved in this type of work dealing with fluorocarbons and analysis, and we have Max Friedberg being totally responsible for this application, he would have intimate knowledge about this. And then, so that would lead us to the notion that this information could be used adversely to NCC in the present litigation. Now, what complicates this is it's 20 years later, but that really shouldn't impact our decision. I mean, you just can't say automatically 20 years has passed and that means everything is fine. Another wrinkle to this problem was that NCC's waste treatment research was not public knowledge, and there's the question of whether or not this research is obsolete or not now. And then there's also the question, if someone leaves the firm, does the conflict leave with them? Now, if Max Friedberg had left this firm and there was no one else there who had confidential information or any other type of information that could be used against the former client NCC, then we're home free. But you know, under imputation rule 1.110b, you're talking about someone leaving the firm, and then you ask the question, is someone still at that firm who has that confidential information? So notice this in the fact pattern. While Friedberg is no longer associated with the firm, there is indeed an attorney remaining at the firm who may have information. Now, the facts sort of make it murky. She was a first-year associate working on this. She does remember a little bit of the facts. Now she's a senior partner dealing in another area of law. But what she does remember is something interesting, that there was some disagreement about compliance issues within the company, and that's interesting. So just because she says she can't remember isn't relevant in terms of us analyzing this conflict. We're looking at the type of information that an attorney in this line of work would have normally obtained in the representation. So the fact that she says she doesn't remember is irrelevant. And so I said in the real case, this was a state of Minnesota against 3M, Minnesota manufacturing mining. They make the Post-its and tape and Scotch Guard for couches, all that stuff. Anyway, so but they were dumping fluorocarbons into the river, and 3M sues for disqualification. The law firm was Covington and Burling. Now, the trial court disqualified Covington and Burling as violating Rule 1.9. You're doing something materially adverse to a former client based upon substantially related litigation matter. But then the Supreme Court of Minnesota remanded the case. It really asks two questions. Had the confidential information become public in 20 years? So some of you made that distinction. If everybody knows it, there's no confidence to keep secret. So did this confidential information become public? And then finally, did 3M waive its right to claim disqualification by waiting until Covington and Burling does so much work? So of course, look at that. Sometimes parties try to be very tactical and they'll just wait, and then when we get almost motion to disqualify. And so that became a part of the analysis as well. Now, where we left off in our last class was on this other problem that we had set up, and that is on page 361, a brief consultation. And I think what we had done was we set up the facts, and we're going to figure out the arguments for disqualification of Hadley and Davis and against disqualification. And we're looking at really three rules at the same time. We're looking at 1.7, because there might be something currently that we are doing that conflicts with our formal representation. We're looking at formal representation, of course, and then we're looking at imputation. So interesting facts here on page 362 or thereabouts. We have an attorney who moves from her old firm where she was consulting with Davies and Davies on tax matters. She moves over to Shoemaker and Watson, and now that former client that she was consulting with on tax matters is suing Summit Bank. And so you see in the middle of page 362, the firm looking at this conflict and trying to deal with it. You have Avella Swain on her firm that a year earlier, Davies and Davies contacted her at her firm to retain her for expert tax advice. So this was when Hadley and Summit was still negotiating, trying not to litigate. She agreed to do that work. She has copies of correspondence. She explained what the client wanted, what the claims would be, what defenses would be, what would happen if the negotiation failed, and how Hadley would respond to those defenses. So we're, on some level, giving tax advice, negotiating for Hadley in a potential suit against Summit. You notice this language on page 362. It seems to suggest in this block quote that there's a continuing relationship. We will assist your firm in reviewing income tax issues related to the Hadley Farm suit against Summit Bank and such other matters as are agreed to in the future. You see in the facts, there's nothing that really cuts off that engagement. It's still there. So the question is, there a continuing relationship, and then that's going to impact on whether or not Hadley is indeed a former client. Notice we did screening. So we didn't even try for informed consent. We did what we can do under the rules. Imputation. We have one lawyer moving to another firm who carries a conflict with her. We identify that conflict, and we screen that attorney. And you see the screening on page 363. We gave written notice that really tracks the rule, but we leave out a couple things. We leave out their right to challenge this in the tribunal, and the right to ask questions from us that we will provide updates to. But pretty much this notice of our screening pretty much complies. Didn't really do a certificate of compliance, but I don't know. But we both signed the letter, the conflicting attorney and our firm. And then we found out that Hadley, our former client, would not waive the conflict. Davis threatens a motion to disqualify. Davies' law firm waited 3 months before sending this letter requesting withdrawal. and we have these questions at the end of chapter 8. Should we withdraw? So we have to lay out the arguments for and against qualification, and then we want to assess whether or not Davies will be able to persuade a judge to disqualify us from this case. So, state the arguments that Davies would make to support the disqualification motion, and then state the arguments against the disqualification motion. And then we are going to assess, would a court likely grant disqualification in this case? So, what are the arguments that Davies would make for disqualification? Motion to disqualify should be granted. Motion to disqualify should be denied. Okay. So what? I'm going to start appointing people legal counsel. What do we think? Yeah, go ahead, just try it. Yeah, thank you.
I mean,
so you're doing for disqualification?
Yeah, so
okay.
I think Davies would have a good argument, saying just the rule of imputed conflicts, like if one lawyer in the firm has a conflict of interest, we want to find that all the lawyers in the firm have a conflict of interest. Because it's likely that, and I would use this in the argument, it's likely that other lawyers in the firm are going to discuss those matters with each other and have access to each other's files. The firm's going to need to involve multiple lawyers anyway. And the client is entitled to the confidences that could be compromised with that confidence inflicted the lawyer in the firm.
Okay, that's good. That's good. So you know what I'm going to say now, right? Well, what about the screening? Then the screening. That's why we did all the screening.
I think the problem with screening, if I was Davies, I would say the problem with screening is you're asking another firm to self-police and manage its attorneys or associate attorneys. So there's no independent regulation. You're just trusting that they don't leak confidential information.
Yeah, but my response to that would be that's why we have the rule. Attorneys should be able to move between firms. If we interpret this rule literally and formalistically, we're going to stop people from being able to have the attorneys of their choice. And that's why we have screening. And you want to say the screening is ineffective, but the argument is stronger if we determine what type of client Headley is. Yeah, go ahead.
Under Rule 1.9, she's a former client, and she has confidential information. And the attorney has the information other than using it in their case against them. That's a big conflict.
Yeah. But why are we saying screening is ineffective? Because if it's a former client, that works. You're exactly right. Former client, we screen, we give notice. She has no participation. We don't talk to her about it. She gets no money from it. We send a notice to Headley. This is what we're doing. We didn't really do that on these facts, but we should. And then we send a certificate of compliance, and then we say, if you don't like this, you can go to the tribunal and contest this. But you really don't have to do that. We'll keep you informed over and over again. So why do you think the screen doesn't work if it's a former client? Because that's the question too. What about that engagement letter? That's there for some reason. Engagement letter was the relationship with Headley actually terminated. And so why I'm pushing this is it's important whether 1.7 or 1.9 applies. 1.7 is more strict, directly adverse. Notice 1.7 really doesn't have anything about screening in it because we're all one attorney, as you said, imputation. It's a lot easier when we have an attorney moving from the prior firm to a new firm and we say, oh, we found the conflict, it moves all around the firm, but we have screened it off under 110. And that may work with a former client, but can we even say that Headley is a former client? Another question is, did Lavelle withdraw? Notice how the facts are set up. And once we say, well, she got paid the money, she finished the tax consultation, that's that. That's true. But we had this engagement that I think that makes it a little bit more complicated. What do you think? Yeah, that's right.
Well, there's a specific language that says other matters agreed to in future. So we could put that towards her, them being a former client, as far as there has not been other agreements to continue replication.
Yeah, but there could be in the future, and have we closed that off?
Not created.
You're saying you have to formally agree in order to have the matter to move forward. And I'm saying, can you say in this letter that it still remains open? I mean, they have to come together and agree, but are we still sort of waiting around for that time to come? And if so, does that mean that we're not really a former client, we're something else? What do you think?
I think that the representation was very specific, only going to that one matter, and she was engaged for a specific purpose, and that matter was completed, and that would have be effective to end the agreement at the conclusion of that particular matter.
Could this letter be construed, even if we accept everything that you say, could this be construed as a continuing relationship anyway? No, but that's Murphy. I think you make both. I'll just put it Murphy up here. I'll say former client. Because another argument you can make is, even if Hadley is a former client, the screening was incomplete and ineffective. You know, the notice provision is a little bit off. We didn't say, well, we said we're doing this, but we didn't tell them you can pursue this in the tribunal. We'll provide you with updates, and here's our certificate of compliance. There are some things that were, not perfect with the screening, and so that might be something that we will point out as well. Now, we did get a description of the procedure and the statements of the firm and the screening lawyer's compliance, but the notice did not state that review might be available from the tribunal, as I said before. Did not state an agreement by the firm to respond to any written inquiries. So, is this screening really effective? And if it wasn't effective, this disqualification should be granted. But there's a real question about also whether Lavelle effectively withdrew. And that would make Hadley look more like a current client. So even if Hadley is a former client, the argument could be made that screening was incomplete and ineffective because of notice, because of redress to the tribunal, all of those things. Okay, so that's for disqualification. What about against disqualification? Motion to disqualify should be denied. One thing we could say is that Lavelle was simply a tax consultant. But that's correct. Not. Anything else? Yeah, there's a former client. And even with the little things about notice and redress to the tribunal, screening is effective. And another strong argument, Summit Bank is entitled to counsel of its choice. If we apply this too rigidly, we are going to impede lawyers' ability to move. And so notice this, in practice, that's why these comments are so important. So if you have to respond to this motion of disqualification, you can sort of look at the purpose of these rules. And if you look at lawyers moving between firms, comment 4 to Rule 1.9. So we can say, we can take this and sort of turn it into our argument against disqualification. Yes, we previously represented Hadley, however you want to call that, but the principle of loyalty is not compromised because Lavelle was simply a tax consultant expert, not Hadley's lawyer, does not have the same responsibility of advocacy and undivided loyalty that a lawyer would have. That's 1. 2, the rules should not be so broadly cast as to preclude persons from having reasonable choice of counsel. Summit is entitled to counsel of its choice. And that's Shoemaker and Watson. And just because Lavelle was a tax consultant and moves over to Shoemaker and Watson does not mean that the entire firm should be disqualified. And 3rd, the rule should not unreasonably hamper lawyers from forming new association and taking on new clients after they have left their previous association. So you would say that's a textbook example of this. And again, the firm should not be disqualified. What do you think happened in real life? In a real case? Initially, the trial court denied the motion to disqualify. It said even though the screening was not totally perfect, the screening was sufficient. So the trial court denied the motion to disqualify. But then the Supreme Court reversed and disqualified the bank's law firm. The court concluded that Hadley Farm was still a client of Lavelle's because Lavelle had not officially withdrew. She never really withdrew, the court said. Lavelle received confidential information from Davies, so you see in the facts all this information on page 362 that she received. And the attorney-client relationship was not automatically terminated by her moving from her old firm, Lavelle, as a tax consultant, to Shoemaker and Watson. So that's interesting. Look on the box on page 365, that chart. That's a good summary of everything that we did, and particularly with the toxic waste case. So it's just sort of pinpointing when you use these rules. You don't have to know rule numbers for the exam or for the NPRE, but this is just telling you so you go back and review the rules and you know which rule applies to a particular situation. So remember, we started off with 1.98. That's not in the chart. That's where everybody is in the same firm. There's been no movement, and we have to be concerned about something that we did previously impacting our current litigation or whatever matter we're on. In other words, something that we're doing currently doesn't undermine or undo something that we did in the past, former representation. But there's no movement there. We're all in the same firm, and maybe we did some work for NBC 5 years ago, and now we want to do some work on Netflix, and we want to develop a new sitcom based upon this new model or something. And we did the work for NBC, and now we're trying to innovate that. And NBC, our former client, might say, well, you're doing something that's going to undermine the market. And so that would be the analysis we'd have to do. Is it not the same matter, of course, but substantially related? And so notice in that scenario, no one has moved, but what we did before may be undermined by what we're doing currently. And then our discussion would be not on the actual information that we had, but on information that an attorney in that TV market would normally have access to, again, whether or not that would materially adversely impact our former client, NBC. So that's 1.9A, but 1.9B on page 365 talks about the migratory lawyer. That's Lavelle up here. She moves from a previous situation to a new situation. That conflict comes with her, and then all of us are impacted by that conflict. And then the question is, what can we do about that? So that's 1.9b. Lawyer moves to a new firm. Imputation, that just underscores the fact that the point that I made before. We're asking, do other lawyers have conflicts because of the migratory lawyer's previous work at the former firm? So when Lavelle comes over and moves over to us, she may have a conflict, and we may also have conflicts based upon her previous work. So we have to look at imputation. Not only does her conflict run throughout this firm, but we may have conflicts because of that previous work. That is the scenario that you have in 110A. We are all one lawyers for conflict purpose. And then 110B, if you look at it, the lawyer leaves the firm, does conflict go away? So after the lawyer leaves, like Freeberg in the toxic waste case, do conflicts remain with the former firm? Does it remain if there is no attorney with confidential information? But if you remember in the toxic waste case, Pastoral had some confidential information. And again, it wasn't actual. You just have to look at what type of information an attorney in that position would have had. So if you look in the last section of this box on page 365, lawyer leaves the firm, does the conflict go away? We cannot represent a person whose interests are adverse to a current client, but may represent a person with interests directly adverse to those of the client, reasonably represented by a lawyer no longer with the firm. In other words, this is the formally associated lawyer's client, and if there's no one there left with information, we can represent. In toxic waste, we couldn't because there was some indication that Pastoral may have that information. So if you ever have this scenario, you are analyzing that under 1.10b. A lawyer remaining with the firm, does that mean that the conflict stays there after the former attorney has left? Who else at the firm could have information even though this attorney leaves? So don't automatically assume that just because the attorney leaves the firm that the conflict goes away. And if you look at comment 5 to 110b, yeah, see, it says, moreover, the firm, this is comment 5, the firm may not represent the person where the matter is the same or substantially related to that in which the formerly associated lawyer represented the client. And any other lawyer currently in the firm has material information protected by 1.6, confidences, and 1.9c, information that could be used to the disadvantage of the former client. So that was the toxic waste. Adam Freeberg dies, and the facts want you to say, well, it's over with now. It's 20 years old, he passes away, he takes all the information with him, but we still have someone who worked on that matter and may have access to that information. And so the conflict still exists. That's what 110b does. After the lawyer leaves, do the conflicts remain at the former firm? Okay, good. So that's former representation. Now we sort of take a little collateral issue, but it's always important. When we first started talking about conflicts, we talked about the structure of the legal profession was self-regulated. We went through the procedures of how lawyers are regulated, and we always kept this notion of self-interest in mind. And now we see that in full bloom when we look at Rule 1.5b. So we're going to go through all of 1.5 before we even work through this chapter. Sort of illustrate. And so now the conflicts that we're talking about are a little bit different. We are talking about our self-interest and how that impacts the representation of the client. So that's, it's going to impact competence and diligence and communication and scope of representation, all that. But the bedrock issue that we're dealing with is our self-interest. We need to get paid. We're not trying to, make a fortune. We're certainly trying to be compensated for exactly what we do. But we have tremendous discretion in doing it. You notice how this rule is set up. I mean, what is reasonable? And then what would we consider unreasonable? That is what this chapter is about. And so our first task here is to figure out how 1.5 works. So what we're doing here, doing a number of things in this chapter. If you look on page 369. So we've emphasized our own professionalism. This is a learned profession, our own judgment, and the restraints that go on how we practice law. And so we're going to look at lawyer-client contracts. We're going to look at restrictions on contingent fees. We'll see that there's a balance. We want to provide access to legal services for people who may not be able to afford it. That's why we have contingency fees. And this is one of the rare instances where an attorney has a stake in the outcome of a matter or litigation. We really don't want to have that stake in the matter because it undermines our ability to be neutral and focused. But there are some instances where we say contingency fees work. We will see later that there are specific areas where there's a clear bright line exclusion from having contingency fee agreements. We don't want them in divorce cases because you sort of are trying to reach a particular result so you can get paid and get a percentage out of someone else's misfortune, and you may exacerbate that situation. So no contingent fees in divorces, no contingency fees in criminal cases either because of that liberty interest. And also if the lawyer wants to get paid, the self-interest may make the lawyer do things that undermine the Fifth Amendment and the Sixth Amendment and other constitutional protections as well. So we'll see that. We'll also look at whether or not we can provide financial assistance to clients. Probably not, that's a bad idea. We don't want to, again, gain a stake in the outcome of a matter that we're handling. And also, that may be an improper way to attract clients. If clients on the street get the word that you're willing to pay for expenses, where does that lead? So that's a prohibition. What happens in fee disputes, and then management of client trust accounts. And then finally, restrictions on business transactions. Another instance where we say we really don't want the attorney and client to enter into a business relationship, but if you must, you'll see that the rule is so rigid and layered that it's really trying to discourage you from entering into a business relationship. But if you do, you need 3 writings, and we'll talk about that under Rule 1.8. So, look at page, 371, reasonable fees. How does this rule work? 1.5, 1.5a. So, here is the here's the preamble to this rule, 1.5a. A lawyer shall not, mandatory, make an agreement or collect unreasonable fee. or an unreasonable amount for expenses. So we have tremendous discretion, but we have to make sure we do not make an agreement for, charge, or collect an unreasonable fee. But the question is, does the rule give us a definition? What is an unreasonable fee? What is an unreasonable fee? How do we know?
By the surrounding circumstances, right?
Okay, how do you get that? Surrounding circumstances?
So maybe what the custom is for that type of work, like custom charge or something. If you got to do extra, something about the client, maybe the client's owns a pay grade with their status or something, their company if they're a person.
Okay, so that's good. Where are you getting that standard from?
From the community and from
No,
other
from
people.
like the rule itself, 1.5.
I just feel like it's open, so it just says unreasonable, but there's such a range that allows you to.
Go ahead.
I don't have much to say. That allows you to just deal in different work, and then it kind of accounts for change in prices over time. So
okay,
by
so
leaving it open.
be very careful now. So let's say you start your own mid-sized firm, you have rent to pay and all this. You get, let's say you do general business transactions, and you don't check the community standards or anything. You just say, well, for this type of transaction, this contract, I always charge $5,000. Now, what about that? Is that how?
So you could be.
And then I can say, well, using your argument, I can say, well, that's not unreasonable. I have a lot of work to do. I need to sort of research the field, take my time, and so it usually evens out to about $5,000, and that's what I'll charge. So what?
Well, so if I ran a taxi or something for $5 like trips, I charge $80. I think it'd be unreasonable. So I should know, right? I should try and get a feel of it and research. I think it's on the lawyer to research it.
Yeah. You should know. Gotta be careful. Okay, let's go.
The rules do give you some factors that you're supposed to take to like calculate it based on like the amount of time you put in case.
Okay, so good. So how would you deal with the sort of hypo I was posing, Mr. Johnson answer that we have to be able to assess what is reasonable and unreasonable. That's the tension in the rule. It gives us a lot of discretion, and you say we should know, but then how do we know and apply this rule?
By using those factors,
Okay.
that's how you assess what's reasonable and unreasonable.
So notice one factor I brought up. So this really, I don't know. This is really interesting. So, like this first factor, time and labor required. I can just say, well, this is going to take me a lot of time. It's going to take me away from some other things I'm doing. I'm going to have to spend a whole afternoon maybe researching this. Then I'm going to have to draft it over the weekend. That feels like $5,000 to me. So what about that?
That's one of the problems with the rule itself is that it is so open-ended, which means it's very subjective.
And so that means that in order for the lawyer to protect herself and get as close to objectivity as the lawyer can, she has to look at more than one factor. So, time and labor, that's good. But that doesn't mean, well, you could always say, wow, this is going to take me a lot of time. I usually charge $5,000, but now I think maybe it should be $7,500 because I have to do a little bit more work over the weekend, and Monday that's going to take up time. So $7,500. Time and labor required. So that's not going to get, you have to look at a number of different factors. Preclusion of other employment. Now this is a good one. You sort of intimated this. The fee customarily charged. This is a marketplace constraint. Fee customarily charged in the locality. So we're going to see in a lot of these cases, we're going to look at, well, yeah, that's how much that normally costs. So if I'm saying $5,000 to do a little research and drafting of a contract, and that's out of whack with the locality, that's a clear signal that this may be an unreasonable fee. Notice this is scope of representation. The amount involved and results obtained. But this is another example why you have to look at everything. You can't just say, well, I got you the result you wanted, I can charge you whatever. Or you agreed to this and I got you the result you want, so whatever. We have to make sure it's not unreasonable. Time limitations. Relationship with the client. Another thing that might affect it, maybe this is, maybe we are involved in complex Supreme Court litigation. There are only 5 people in the country who handle these type of appeals. That can make the price go up. But then notice all of those other factors come into play. If this is a small marketplace, the price may be a lot higher, but that would be the fee customarily charged in this segment of the profession. Advance the appellate work to the Supreme Court on this small, discrete number of cases. That could impact the price as well. So experience, reputation, ability of lawyer. And then fixed or contingent fee. So those are just things to consider, not an exhaustive list. Notice this, so that shows us how much flexibility we have in actually setting the fee. We look at all of these factors, not in isolation, but as part of our mix. Factors up on the board are not exclusive, nor will each factor be relevant in each instance. The lawyer may seek reimbursement for the cost of services performed in-house, such as copying and that type of thing. We have to let the client know in advance. So that's one thing. Another thing is, this is interesting. I'll just quote 1.5b talks about preferably in writing. This fee agreement. So, that tells us we have some flexibility in whether or not we even want to put this into a writing. So, scope of representation, our basis of the fee, expenses, all of that should preferably be in writing before within a reasonable time after we start the representation. Now, if the client will regularly represent the client and the client already knows about this, we don't have to go through all of this. That's what the next little section of the rule says. Except when the lawyer will charge a regularly represented client on the same basis or rate. So preferably in writing. But notice this, any change in the basis or rate of the fee or expenses shall also be communicated to the client. It doesn't specify in writing or not. So you have to be careful with that, just unilaterally changing how much you're charging for fees. That could be a problem as well. What does it say about contingency fees? I want you to sort of point that out to me in this rule. 1.5C, what does that say? So we can have contingency fees, that's what letter C says, except those that are prohibited in letter D, and we'll get to that in a minute. Nothing in domestic relations, nothing in criminal cases. But what about a contingency fee? That seems to be a little bit different and more formalized than just a regular fee. Why do you think that is? Why do you think the rule is set up this way? Contingency fee shall be in writing. Signed by the client. Why is that? What makes it so? Yeah.
I think a big part of this the client, it keeps them from saying that you're taking part of their settlement money because they're agreeing to something that's, I guess, technically theirs that you're taking. And then I think it's maybe like a safety thing for you, so that you can show they consented to be taking this amount of their settlement money or whatever they were worth.
Okay, that's good. So we want this to be in writing, and it's going to tell us the method by which the fee is determined. Notice in some way this has to be more strict because you are consenting to having a stake in the outcome of this matter. And so we want the client to be on board with that, and we both want a meeting of the minds about how things will be divided if we are successful. So the client should know the method by which the fee is determined. I'll just put percentages, including the percentages that shall accrue to the lawyer in the event of settlement, trial, or appeal, litigation, and other expenses to be deducted from recovery. So notice that's going to impact the recovery itself. And then whether expenses will be deducted before or after the contingent fee is calculated. And if you look on page, I'll put C page 400. If you look on page 400 of the text, you'll see that it matters whether the expenses are deducted before or after the contingency fee is calculated, because this is why we want the client's agreement to this distribution. The client will recover more if the fee is calculated after expenses are subtracted. Yeah, you see that on page 400. So the client receives more if expenses are deducted after the lawyer's fee is calculated. After expenses, the client recovers more. You see an example on page 400, it's $4,000 more, so that's not insignificant. And so that's why you want all of that in writing. And then even after that, if you explain the method by which the fee is determined, the percentages that will accrue in the event of trial, appeal, or settlement, how litigation expenses will be deducted. After you do all of that, there's another component of the rule that says the agreement must clearly notify the client of any expenses for which the client will be liable, whether or not the client is prevailing party. So we may have to copy and Xerox and package and index a lot of things, and we're unsuccessful. And the client might think, well, we didn't win, so that's contingency, we don't have to pay anything. Expenses have to be clearly outlined to the client. So those are expenses. Upon conclusion of the contingency fee matter, this is important as well, the lawyer has to provide the client with a written statement stating the outcome of the matter. And if there is a recovery, showing the remittance to the client and the method of determination. Let's put expenses, even if unsuccessful. If successful, remittance, and how it was determined. So again, this is a rare instance where a lawyer has a stake in the outcome. And so we want client agreement on all of these things. Now there's a clear bright line exclusion under 1.5D. A lawyer shall not enter into an agreement, contingency fee agreement, in a domestic relations matter. So notice that would be contingent on securing the divorce, and you might do anything in order to secure that divorce in order to get payment. So that's the lawyer's self-interest against the client, so we prohibit contingency fees there. Same thing for a criminal case. And then finally, a division of fees. We don't want lawyers just sort of referring matters here and there. Notice there is some level of responsibility in that particular situation. We look at 1.5A. We can divide fees between lawyers not in the same firm. You know, that may be a referring lawyer to a lawyer with expertise in a particular field, provides representation. But notice the requirements under 1.5A. The division has to be in proportion to the services performed by each lawyer, or if it's not proportionate, each lawyer assumes joint responsibility for the representation. So that's ongoing. The client has to agree to that arrangement, so the client has to actually know this representation, including the share and what the lawyer will receive. And that agreement has to be conformed in writing, and the total fee has to be reasonable. So it's interesting. The two times that a writing is mandatory is when we have a contingency fee or if there is a division fee. At the initial, no contingency, divorce. Division fees. Okay, so that's 1.5. But we still don't have a good answer about what is reasonable or not.
Just so you're not going to guess a good answer.
Not going to get a good answer. Okay, so that leads me to this. This is good. So look on page 373. How do you deal with these? Unreasonable fees, an example. So there's no definition in the rule, as you point out. How do you explain some of these cases? Like, notice this first one. This sticks out to me. The client doesn't object. The client knows this is going on, I guess, but the lawyer still gets in trouble. Why is that? So the lawyer's usual rate is about $200. He charges $275. He charges more because he didn't know the state's law. His assistant does some of the work, but he still bills as lawyer time. And the client did not object to the fees, but the beneficiary did. So what's wrong with that? Why did the attorney get in trouble in that first example? Why did he get in trouble?
So he charged $25 more than he does.
Yeah, $75 more. Yeah.
No.
Yeah, $75 more.
Weighing
And
all the factors, it doesn't seem like there's really any good reason why he charged more.
Mhm.
It is pretty much.
he charged more because he did not know the state law. So I'm charging you to get up to speed. What's wrong with that?
We really don't want lawyers to learn on the job and build their lives for it.
Yeah? Why can't I make the argument I'm enhancing my expertise so I can be competent and diligent under the rules? And this is just the cost of doing business. And that's reasonable.
So there's continuing education credit should be.
That's great. Yeah, that's good. That's good. Okay, go ahead.
It really doesn't make any sense if one of the factors is that you look at how skilled and experienced somebody is and they can charge more, then why would a less experienced person be able to charge more?
That's good. That's good. But then so all of you will just be starting out. Then how do you gain the expertise to be able to charge a reasonable fee? I mean, we can't charge the client to learn. What do we do when you first start out practice? What are you going to do?
I just think that at first you're going to not make as much money. You're going to spend, more time.
And that's why you have supervisors. That's why you have more senior attorneys. So whatever context you're in, remember this: when you're getting your first assignment and you're finished talking and they haven't brought it up, you sort of bring up, has anyone done this before? Can I have them out? I would always do that. And then notice it does two things: you're clued into how your organization does the work, what is required, and you're saving the client money because you're not reinventing the wheel. And a good supervisor will really say, well, Jane has done this before. Check with her. It may not be exactly on point, but she has the knowledge to do it. And so that's how you gain expertise. There'll always be someone supervising you. And so we really don't want the client to pay for lack of expertise. You have to locate expertise somewhere and associate yourself with that expertise in order to provide competent representation. So that's a good segue to Fordham. Look on page 375. Interesting. Now this is $50,000, and we want to know if this fee is unreasonable now. So this is the classic scenario. Your families will probably always say, well, I get this. You're a lawyer, so you know, they just assume you know about tax or secure transactions or criminal law or anything. You're a lawyer, so you practice, so you know. And I think the general public doesn't understand this notion of expertise and specialization. And this is a great example of that. Fordham is a managing partner, so very accomplished in his field, but he's never represented a client in a criminal matter. This is a DUI. And so he decides to represent the son of someone who was installing a alarm system in his offices. He says, okay, I'll take this on, but I need to get up to speed. I don't practice criminal law. I practice corporate litigation and the like. So he's at a major firm, Foley, Hogan, Elliott, major Boston firm. Never represented anyone in a drunk driving case or even a criminal matter. But he spends lots and lots of time, does the necessary work, introduces a novel theory, and gets his client acquitted. This is on page 376. And you see a series of bills. Now, this is an older case. You know, billing isn't done like that anymore, and clients won't stand for it anymore. They want particularized notation of what you did. It's no longer services rendered or for work completed on. They want to know what you did. And so he sort of took the cursory approach, just offering a series of bills, totaling $50,000 for 227 hours of work, 2/3 of which was performed by Fordham himself. The usual charge for this type of matter is less than $10,000. And he also did something, a retroactive increase of the fees. One of the bills included a $5,000 retroactive increase. It doesn't seem like there was any notice or anything. This was just built into the bill. So that's another inappropriate thing. So notwithstanding the novel theory and results, was this fee reasonable? The court concludes, yeah, the fee was unreasonable. The fee was unreasonable. And this attorney was publicly censured. Now everyone knows, there's no doubt he was diligent. No one doubts that. Got a great result. But the fee was nevertheless unreasonable. Why was the $50,000 unreasonable? Because notice this, if you base it just upon, think if we did it like this. You got acquitted, cost $50,000, $50,000. But even with all of that, the court says that this is unreasonable. What made this unreasonable? And on some level, the attorney could argue, well, this client knew my hourly rate, $200 an hour. But the client didn't know that the attorney would spend almost $300 on this. That's the thing he didn't know. Go ahead.
It seems like, to me at least, one of the differences is that most cases are the total cost of less than $10,000, whereas
Yes.
this one is $50,000.
5 times more, yeah.
And then also, the way it was billed, like what exactly was that time spent on? Because the attorney also said, well, I need to be caught up with the law, I don't need to handle criminal matters. So how much of that time, of that bill time was spent in the actual research, how much time was spent in documents, how much time was spent, like actually doing the prep work?
Right.
And is that actually billable?
And is it billable if we are paying for the attorneys getting up to speed or learning this area of law? Now you could say, well, the client knew that the attorney didn't have this expertise. That's what the client signed up for. But the court probably would say the client didn't sign up for $50,000 worth of education on the job, even if we get the appropriate result. But there's something else. What about this? In effect, the client signs a promissory note for these fees. What about that? Isn't that informed consent? And then if that's so, how is this unreasonable if the client signed for it?
Especially if it's somebody who didn't read the document all the way through and realize, okay, where's the account to pay?
Right. So let me say this. So sort of, does this rule give us enough guidance so that we would be able to avoid discipline? Because that's one of the questions here. So the questions about Fordham start off. I think it's clear that he billed too many hours on this matter. That's clear. You know, you look at all the standards up there and the cost. The time and labor required was expanded because he didn't have the expertise, so the client is paying for the attorney to learn on the job. So that's clear. But then the second question is the guidance provided by the rule clear enough to be a basis for discipline? Under 1.5. Because 1.5 gives us discretion, but it also doesn't give us much guidance in terms of avoiding discipline. So that's a problem. I don't think there's an answer to that. Look at number 6 on page 378. Now notice this, number 6 is in there too. That question number 6 is in there to draw a contrast. So Fordham, we have a client who's fairly sophisticated, but we say that this is still an unreasonable fee because the client is paying for the attorney's education on the job. We don't want that. So now we have sort of a higher level client sort of negotiating for this type of representation. I mean, the state says we need you to represent us against the tobacco companies, and the tobacco companies have a record of 800 to 0. They've never lost a case. And so the only way that the state can keep up is to enlist the services of this firm. And they agree to 25% of damages if the state wins. There's 100 lawyers on the case. There's no certainty that those lawyers will ever be paid. The state agrees to these terms in writing. And eventually, the state wins an $8.3 billion settlement from the tobacco companies. And so the law firm says, we signed up for 25%. Where is our $2 billion? If the firms had charged per hour, it would have just been $20 million. But given the uncertainty and the fact that the tobacco companies had never lost, the state agreed to this contingency fee of 25%. 25% of $8 billion is $2 billion. And the firm says, where's our $2 billion? What about that? We just said that 50,000 was unreasonable. Is $2 billion unreasonable if the state agrees to? Yes, right.
I didn't think it was unreasonable because I think one point we haven't been on yet is whether or not the case precludes other employment. And here you've got like 100 attorneys that are locked up for months and months without making other employment. In the other case,
this wasn't a small firm. This is a major, international. So 100 lawyers, there might be 1,000 lawyers at the firm. But you're right. Those 100 lawyers cannot do what they normally would do because they're focused on this case. That's right. Go ahead.
Yeah, that's what I was going to say. And in the previous case, we didn't need to use 227 hours on
right.
the line.
That's good.
We could have had other opportunities to make that $100.
Yeah. For government, it's funny. The taxpayers are going to be kind of, they already have a sort of skeptical view of lawyers. And now we want $2 billion. So the government sort of got nervous about that and said, well, we can't give you $200 billion. We'll give you $775 million. That's a lot of money. I mean, almost to $1 billion. But the state said, well, the only thing that we can give you is $775,000. So of course there's a trial. Law firm was like, hey, wait a minute. We have a contingency fee. You signed up for this. You knew it. It was speculative. We tied up all of our resources. We weren't sure to win, but now that we did, this is what you agreed to. What do you think the jury did? What do you think the jury did?
Say no.
Said no and yes. The jury ultimately awarded the firm only $100 million in additional fees, in addition to that $775 million. So $875 million was paid out, but not $2 billion. Is that even reasonable if you compare that to the $20 million that they would have made hourly rate? That's what happened. So let me set up this unreasonable fee. When we come back, we're just going to do unreasonable fee, talk a little bit more about what's in this chapter. We will do the only other problem in this chapter, and then we'll start moving into chapter 10. Most of chapter 9 just talks about the different type of fees, so we'll talk about that. But let me set up an unreasonable fee. So we have a situation where repairs are made, and a tenant is not really satisfied. She hires a lawyer, Colin Horlick, to settle a dispute with a landlord, responsible for the cost of cleanup and renovation during a flood in a luxury apartment. Landlord had refused to cover the repairs. Ingrid paid $70,000 to have the work done on her own. Colin told Ingrid that his rate was $250 per hour. This attorney, she agrees. They meet only once after their initial interview, and the meeting occurred several months after she retained him. So in the meeting, she described what he's done so far, and he told her that he had already put in 88 hours, but did not specify the size of her bill up to that point. That's a problem. He explained that there's still much work to do. We're making some progress. She says to him, keep going and get that guy. So the attorney pursues this matter vigorously, devoting so much time to the matter that his bills to Ingrid, his client, total $45,000. So keep in mind, $45 of litigation expenses on a $70,000 claim. So the attorney spent many hours on research about the landlord's responsibility, more time on fact investigation, interviewed many clients to determine if they had any problems with the landlord covering costs. And then he persuades the landlord's lawyer to participate in mediation. So this is another process, which takes many hours, but produced no settlement. So eventually Colin files a lawsuit and deposes the lawyer and the landlord's accountant. When Ingrid gets this bill from Colin, she is aghast. And she comes to consult us as professional responsibility attorneys about whether or not this bill was excessive. Ingrid points out to you that even if she ultimately collected the full $70,000 for the work that she had done that the landlord court refused to do, she would have spent most of that amount on legal fees to obtain the recovery. So this is another example of amount involved in the results obtained. May have gotten the right result, but how much did you spend in order to get that result? How would we evaluate whether or not the attorney actually is charged an excessive fee? What other information do we need? And apart from Rule 1.5, has Colin violated any other duties to Ingrid under the rules of professional conduct? I can think of some, so look at this when you analyze this problem. 1.4, communication. 1.3, diligence. 1.2, scope of representation. And then this whole notion of going to a mediation process, we're probably discussing it with the attorney. So we're going to look at unreasonable fee, and then from there, the rest of the pages really talk about different bills. I'll sort of summarize those and point them out to you. And then we're going to do the impoverished client. That's on page 405 when we come back. And then we'll finish up the chapter and start moving into chapter 10. Have a good weekend.